Hi, I'm Diana Levine from Marshfield, Vermont. Should a manufacturer get away with putting a bad product on the market? Or should they be held responsible for their actions? I have personal experience with this, which I'll tell you about later, but first, I'd like to introduce you to Don Hickey from Eskridge, Kansas.
I'm Don Hickey, and this is my beautiful wife, Jackie. We live in the middle of America, and I'm a retired pastor and grandfather. One night, not too long ago, I was getting ready to go to bed, and as I walked into the bedroom, this device that's implanted in my chest right here started to shock me, and I thought that I was going to die, and I cried to my wife, "Call 911," because I thought the only time this defibrillator was supposed to go off is when my heart had stopped and I was flatlining. And I was shocked several times before the ambulance arrived later.
Don underwent heart surgery to have the faulty part replaced, expecting to be safe from future shocks. But after the surgery, he was surprised to learn that they had replaced the defective product with the exact same type of device. Believe it or not, due to a recent change in the law, medical device manufacturers can evade responsibility for products that hurt people, basically to hit and run.
That was kind of, frankly, the hell that I started living with after that, because I didn't know whether it was going to go off or not. I didn't know whether it would be real or not. So what do you do?
And the doctors thought that it was too risky for him to have any more surgery. You know, his heart could stop while he's on the table while they're trying to replace that wire, and he could die right then and there. So we didn't want to try that. So I guess the thing to do now is we just have to wait and pray. And we do a lot of that.
Don, I want to show you the letter that I got from Medtronic, which I refer to as the ha-ha letter. Ha-ha, you can't touch us, where they notified me of their position and cited to me the case law on preemption, where they're telling us you don't have a claim against them. And the case they were telling me about has now been affirmed by the Supreme Court of the United States. Let me explain to you what preemption means. Preemption is a judge-made doctrine that because the Food and Drug Administration has approved this device under its procedures, then you can't make a claim against them for any defect in that product. And the case they were telling me about has now been affirmed by the Supreme Court of the United States. So that will essentially kill your claim for the injury you received in January of 2007 when that device shocked you.
As a result of the U.S. Supreme Court decision, thousands of lawsuits have been thrown out by courts across the country. Defibrillators like Don's have actually caused people to be thrown clear across the room. A wife who was helping her husband who was being shocked was shocked herself just by touching him. A 3-year-old girl who was shocked is now terrified of monsters attacking her. A young father who was having the faulty device removed died on the operating table, leaving a wife and 2 little boys. The people killed, shocked, or injured by these medical devices have no place to turn for help. Is that what Congress intended?
I was in the Congress when that law was adopted. There was never a discussion of preempting state laws on liability. It's essential that we have the ability to sue, because not only will it mean the injured party is compensated for the harm that's done, but it's an incentive for the manufacturer to make sure that the product is safe, and that if there's a risk, that people be informed of that risk so they know what they're getting into if they use a drug or medical device.
I've spent years as a consumer advocate, and what we're seeing now are companies that are using the doctrine of preemption as a shield, and when in effect it's actually hurting consumers. Congress needs to go back and explicitly state in those statutes that this statute was not designed to preempt state law. That's the one course of action that we know that will provide consumer protection against preemption.
I've introduced legislation with a large number of co-sponsors to make sure that we're not stopping the state law from operating when a party is injured, from suing the responsible cause, the responsible party that was the cause of their injury, the manufacturer of the medical device.
A while back, I was in the same boat as Don. I went to a doctor with an awful migraine, and due to an inadequate label, they administered a drug in a way that should not be allowed. Over the next few weeks, I watched my arm turn black with gangrene and had to have 2 amputations. I lost my arm, and it didn't have to happen. Recently, the United States Supreme Court ruled that I have the right to sue the manufacturer of the medicine for their bad label. I finally got some justice, but it took 9 long, heartbreaking years. I won my case, which is the best thing that could have happened, except for getting my arm back. But that doesn't do anything to help Don Hickey, or those kids who lost their dad, or any of the people who've been hurt by medical devices. If you can't hold a corporation responsible when a product that got FDA approval hurts you, that's like giving the corporation a license to hit and run. It's like saying, if a drunk driver crashes into you, he can't be held responsible because the state gave him a driver's license. This is the U.S. Supreme Court ruling that gave me and people like me the right to sue. But what's really crazy is now there are 2 laws. The Supreme Court has said that people like me who are hurt by bad drugs can sue, but people like Don, who are hurt by bad medical devices, cannot. It's time we finish the job. We need to all work together to pass the Medical Device Safety Act. We need you, because there are people all over America like Don Hickey who need to win justice. And it shouldn't take 9 years.